Hi, everyone, and welcome to episode 4 of the Exeter Law Review podcast. My name is Shania Essah Aurelio, and I am one of the co-editors-in-chief for the Law Review this year. Today, I am joined by Francis Hand, who is our co-editor-in-chief, Fizaa Ahmed, one of our managing editors, and we also have Celine Oyguch in the call today, our general secretary, who will be making sure that this recording doesn't collapse. Thanks, Celine. And we are joined today by Dr. Adam McCann. Hi, Adam.
Hello.
So just a little bit about Adam. Before he joined the academic team at the University of Exeter, he completed his LLM at Utrecht University and his PhD at the University of Groningen in 2016. Adam's PhD specifically focused on the legal framework surrounding end-of-life medical decisions in various jurisdictions. And interestingly, his PhD thesis is the most downloaded Exeter Law School research output in the last 12 months. So although Adam focused on 4 national and 2 supranational systems, we will mainly be comparing the approaches in Switzerland and in the UK. So thank you for joining us today, Adam.
Yeah, you're very welcome. And first of all, congratulations on this initiative and the podcast. I think it's brilliant. I think it's a really cool idea. And your pronunciation of the Dutch cities was perfect.
Thank you. Because I was about to say unfortunately I study French law, not Dutch. So I was just like, it's the French R. Anyway, so before we start getting into the deep ethical arguments of medical law, would you mind outlining what the legal standpoint is in both the UK and in Switzerland?
Yeah, of course. So in the UK, voluntary active euthanasia, that is the termination of another person's life upon their request, is a crime. It's deemed murder and carries a mandatory life sentence. And that's regardless of how much the victim was suffering or how much the victim requested assistance. Equally, assisted suicide, which is the assistance of assisting another person in ending their own life, is also a crime. It's deemed a lesser crime than murder. It carries a maximum penalty of 14 years in prison. So that's the breakdown between assisted suicide and active euthanasia in the UK. In Switzerland, voluntary active euthanasia is a crime. However, assisted suicide is lawful. It's lawful provided the person providing the assistance acted without selfish motive. So that's why we see the existence of various right-to-die clinics in Switzerland, such as Dignitas in Zurich, which is a non-profit organization helping people with incurable illnesses or unbearable pain to commit suicide. So that's the law in England and Switzerland, kind of in a summary.
And then I think the other point that is probably good to put into context as well is how is euthanasia different from assisted suicide? Because I think sometimes people use them interchangeably.
Yeah. So they're both. I mean, whether there's a moral difference between them is a debate to be had. But there is a physical and legal difference between the two. So active euthanasia involves the injection of the lethal substance, usually by a doctor into the patient's body. So the doctor, to be blunt, kills the patient. Assisted suicide involves the self-administration of that lethal substance. So you will drink the lethal substance or inject yourself, while the doctor will prepare the substance or the injection. So it's only assistance in your own suicide. So that's the technical difference between the two. And when a doctor kills the patient, that's seen as murder. But if a doctor prepares a substance which the patient self-administers, that's deemed assisted suicide and a lesser crime.
And I think it's quite interesting because as technology advances, there's a lot more capabilities for people with even the most severe disabilities to commit suicide by themselves rather than by a doctor injecting it. So I think you were saying in a discussion a couple of weeks ago about how you can use the tracking of the eyes,
and
they could administer it themselves.
Yeah, that's true. So there's one of the reasons why in the Tony Nicklinson case for the Supreme Court, his counsel decided not to seek a change in the law on active euthanasia because of technological advancements, that there's a machine available now for people who are suffering from the most horrific physical disabilities and who only have simple eye movement. They can use that eye movement to self-administer a substance by just simply consenting, set up, so to speak, to the system. And that's the assistance in their own suicide. So yeah, the problem is a lot of people see that as a less dignified way to end your life. rather than just a straightforward injection from a physician. To be hooked up to a machine seems a little less human, and not what some people seem to prefer.
That's really interesting, because I would have kind of phrased it the other way. So if you're injecting it yourself, you have a bit more autonomy on the decision, whereas if a doctor's taking that decision away from you.
Yeah, I think that's certainly the argument, and that's what the Swiss believe. It's the difference between assisted suicide and active euthanasia is agency. This idea that you have the final decision to make, and the physical ability to consume the substance is that physical voluntariness in action. But whether it's been hooked up to a machine is more or less human rather than autonomous, I think is a different issue. I think it seems a little sterile and a little bit, maybe not the most dignified way to end your life. That's the argument. I don't fully agree, but that's the argument put forward.
And how much do you think that politics plays into the legal framework of assisted suicide? Do you think that a more liberal, potentially, politics would mean that society would be more open to assisted suicide or assisted dying?
Yeah, well, we have quite a liberal political system already in the UK. We're more liberal than the Dutch when it comes to, let's say, church attendance or religious beliefs, let's say. So that doesn't seem to be the main issue. I mean, this really depends on what we mean by politics. If we're talking about the impact our directly elected officials have on the law on assisted suicide, then I think we have to distinguish between two phenomena. Firstly, the impact politicians have on reforming the law, but also the impact politicians have on how the law is applied. So in relation to the first issue, how much influence do politicians have on reforming the law on assisted suicide? The answer is a lot. And that's not necessarily a bad thing. You know, there are very, very good arguments for parliamentary representation and policy formulation. Political representation via the House of Commons gives a chance to mediate what you could call dissent over different values within a society. So in theory, it provides a voice to politicians, provide a voice to their constituents, and a type of what's called input legitimacy to the law. And that input legitimacy also helps with legitimacy to enforcing the law. So we need democratic processes to inform our laws, and the law on assisted suicide is of course no different in that respect. However, our democratic processes can fail, and we all know that. So look at it this way. Most political scientists correctly assume that the main goal of elected politicians is to maximize their potential to be re-elected. And that's not a criticism. You'd be a totally ineffective politician if you did not have a seat in parliament. So with that in mind, politicians, or even aspiring politicians, have to approach every issue in a strategic way. They have to weigh up the costs and the benefits of supporting a particular issue, and the likelihood that support may have on winning or losing votes. Okay, so with all that in mind, we know when it comes to what's called manifest morality policies, so that's, in other words, acute life and death issues, such as assisted suicide, but also abortion or embryo research, it's better for politicians to serve relevant special interest groups rather than the preference of individual voters, because it's too volatile. We don't know what individual voters will think about those issues. So as far as assisted suicide is concerned, that means politicians, that this isn't just in the UK, but for all the jurisdictions I've studied, pander to the preference of three very important special interest groups: professional medical associations, religious organizations, and right to die organizations. Now in the UK, we don't have a powerful right to die organization, so they're not so relevant in this game theory. So that leaves us with the professional medical association and religious organizations. Now the latter, religious organizations, are not likely to support assisted dying anytime in the future based on first principle morality grounds. But the former, the medical association, at least for the moment, they do not support a change in the law in assisted dying. And that's why no political party in the UK have ever mentioned euthanasia or assisted suicide in their election manifestos. So in other words, there's no obvious gain in putting their necks and therefore their re-election chances on the line. So in that sense, politics does and always will play a significant role in the reform of the law on assisted suicide. Briefly then on the impact politics has on how courts interpret the law. Let's look at the judicial review cases like Nicklinson. Well, in those cases, clearly the majority of the court were concerned about overstepping their institutional powers. They thought it was a decision that needed to be made by democratic actors. As for how the CPS applied the law, so the lack of prosecutions for family members and loved ones who returned from Switzerland, well, the fact that there's been 0 prosecutions appears to be a political compromise. So we're not going to legalize assisted suicide, but we're also unlikely to prosecute anyone who assists a person to commit suicide, provided, of course, they have good intentions. And that's not a satisfactory legal solution, as far as I'm concerned. So yeah, politics plays a huge role in the reform, the interpretation, and the application of the law.
No, you've actually covered, I was going to ask you a bit about it later. So I don't really understand the point of criminalising assisted suicide if they then are only going to prosecute, because I think it was only in about 3 cases, wasn't it, that the DPG actually prosecuted? And that was in cases where it was more selfishness, that they'd kind of almost convinced the person to end their life for their own selfish gain. So it kind of confused me as to why there would be a law if it's never actually enacted upon.
Yeah, well, you're not alone. You're not the only one confused in that respect. And that's one of the major criticisms about the current law. It's deemed what's known as a Chinese proverb of paper tiger. It's meant to look threatening and scary, but in fact, it has no terrifying utility at all. Because in practice, you could say we've one of the most liberal assisted suicide laws in the world. People travel quite frequently. I think there's been over 350 people have traveled from Britain in the last 15 years to Zurich, usually accompanied with a loved one who then returns home and isn't prosecuted. It may be subject to investigation, but then it's not deemed in the public interest to prosecute. And then the question is, well, if it's not in the public interest to prosecute people assisting, then maybe it's in the public interest to reform the law. And I think that's a decent argument. And it's up to the state to justify why they think that's not the case.
I also just realised I said DPD and not CPS. The DPD are not prosecuting people.
I'm just moving on from there. Given the focus on patient autonomy in the UK in other areas, do you think that the UK should consider starting a similar approach to the one in Switzerland in hopes of making the procedure accessible to people in those severe circumstances? Yeah,
I think the law in the UK should probably be reformed more along the lines of the Dutch law on assisted dying. So that means, unlike in Switzerland, we legalize both active euthanasia and assisted suicide, and that we have a careful regulatory framework permitting medical professionals, so not just well-intended amateur volunteers that work at Dignitas, but doctors and nurses perhaps, to carry out the assistance. Now, I'm not saying a complete blanket ban on assisted dying like we have here in the UK is better than the current Swiss law. I think a blanket ban is worse, but that doesn't mean the Swiss law is not without its issues. So there are a number of practical issues, such as the workings of Dignitas, where the assisted suicide has been carried out. There's been a number of cases where it's, let's just say, been carried out in dubious settings. Also, there's the high costs involved. So it costs about £14,000. And remember, it's meant to be a non-profit organization. You're liable under Swiss law if you make a profit by assisting somebody's suicide. And it's not completely obvious to us where the huge sums of money are actually going. But also there's principled issues. So I think by permitting assisted suicide and not active euthanasia, the law in Switzerland arguably discriminates against those who are severely disabled and thus unable to self-administer the lethal substance themselves. So I think in such cases, a doctor ought to be able to administer the substance directly, provided, of course, the patient has made the voluntary decision and is suffering unbearably. Also, by limiting the law to assisted suicide only, it may encourage those suffering from, let's say, an incurable degenerative disorder, such as motor neuron disease, to end their life sooner than desired due to the very real fear of losing physical ability, and that physical ability that's required to self-administer the substance. So for that reason, I think, for principle grounds, we ought to permit both and look more towards the Dutch-Belgian framework than the Swiss one.
Thank you, that's really interesting. And in regards to like procedural or safeguards and requirements, I find it interesting that there's not a minimum age or diagnosis or symptom state requirement in Switzerland. Do you think that if the UK was to kind of reform the law and legalize assisted suicide, that there would be requirements in place?
Yeah, so this is the trickiest question then. The devil is in the detail. You know, there's a lot of questions to be answered. You say, a lot of people say, I'm in favor of legalizing euthanasia or assisted suicide, but then you ask them, well, what's the age limit? Should anybody, should a 10-year-old, like in Belgium, be permitted to receive euthanasia? Or should we look to have a more Dutch system, which is a little bit like our law on capacity, which is if you're 16 plus or Gillick competent, you can avail of assisted suicide. And on that one, I probably would stay with our general law on capacity and limit it to, if we're looking at children, to those who are either 16 years or older or Gillick competent, and not set an arbitrary age limit. But then you have other questions about, well, what type of illness does the person have to be suffering from cancer, from a physical illness? What about mental illness? What about incurable depression? Or should they qualify? And which they do also in the Netherlands. What about people who have dementia and they have an advanced directive for euthanasia? So I sign my advanced directive and say, if I reach a certain level of dementia, I want to be euthanized. Should we permit that? Is there something different about contemporaneous request and a future advanced request? And I don't have a quick answer for those questions. I think in relation to should we allow people suffering from mental illnesses to avail of assisted dying? I think in principle, yes, but we have to be very, very, very cautious, more cautious than the Dutch, when we carry out that assistance. So make it mandatory in law that they are assessed by 2 psychiatrists as opposed to just 1. As for advanced directives, yes, I agree with that. I do think if we believe that the principles behind the law is autonomy and beneficence, we have to respect somebody's autonomy at the moment they write that request, that advanced directive, which we do at the moment for, let's say, passive euthanasia. So if you don't want to have a blood transfusion and you have that written clearly into your advanced directive, nobody can require you to have that blood transfusion. And I think that's correct. And I don't see any moral difference between that decision, which will lead to death, and a decision where somebody instantly injects you with a lethal substance and will lead to death. I think we either respect autonomy and the principle of beneficence, being kind to somebody, or we don't. Yeah, but it's saying that there is something intuitively difficult about the idea of knowing somebody's been euthanized when they've no idea what's happening in the room at the very late stages of dementia. It's a very difficult thing to watch or to know that's occurring. But I think if we're being consistent principally on this, I think we do have to permit that.
That's the thing I was going to ask next, actually. So it must be quite a difficult line to draw between giving this autonomy to patients, but also ensuring that they're making the decision of their own free will, because there is always this kind of story about, this person's been convinced to end their own life because they were told they were a burden to family members and all this sort of thing, that if we say no to any form of assisted dying, then we're not going to have those occasions where people might be talked into it. So where's best to draw that line?
Yeah, so I think this is a question on the procedural safeguards. How well can we ensure that somebody's wish is truly autonomous? Who's the evaluator of that wish? And if you wanted to have the most, let's say, risk-averse policy, you would probably say, well, at least limit it to those suffering from an incurable physical illness. So if you look at the Netherlands, about 85 to 90% of cases are patients suffering from a terminal cancer with less than 3 weeks to live. And I think in those cases, we'd all agree that what's the overriding reason for requesting assistance in dying? It's pain. It's not a sense of feeling like they're a burden on their family or loved ones. It's just the excruciating pain of a cancer in the last few weeks, even the last few days. So you could say, at least if we limit it to patients who are in that situation, you're going to reduce the likelihood that it's just somebody who's been pressurized by family members because they want their will, etc. So that's one option. Another option is just to have specially trained physicians and an open discussion about, decisions to commit suicide and whether you can actually have capacity and a wish to kill yourself. Is that a thing? And have as many experts involved in decision before the actual act of assistance occurs, And that's what they have in the Netherlands. They have a special body called SCEN, which is experts in assisted dying and evaluating consent. But as I say that, it's not foolproof. Of course, some cases will fall through the cracks. But on that point, we do run that risk when somebody refuses life-saving treatment, that they may be doing it because of the costs involved, or because they don't want to be a burden if the treatment fails, etc. So they just want to passively end their life. So we take this risk all the time when it comes to the true assessment of somebody's wish to die. It's about making sure you have as many safeguards. And I think the answer to that is having professional medics, psychiatrists involved at all, which isn't the case in the Netherlands. It's only one if the patient has a mental illness. If the patient has no mental illness, then it's just 2 independent GPs. And I'm not convinced that's enough of a safeguard. Yeah.
Bringing the focus back to the UK, do you think the decision in Nicklinson was correctly decided, or was the approach taken too harshly?
The Supreme Court decision in Nicklinson. Well, I think it was flawed in a few ways. So firstly, the majority, I think it was 7 of the 9 judges, showed too much deference to Parliament. So they said, basically, we can't decide this. It's an issue for elected officials. Now, on that point, they're being asked to make a declaration of incompatibility with the Human Rights Act. A declaration of incompatibility would not have struck down the criminal ban on assisted suicide. It simply would have required that the Parliament debate the issue. So the argument that the Supreme Court cannot make a declaration of incompatibility because Parliament should decide whether the law needs to be reformed totally ignores the fact that a declaration of incompatibility would have required exactly that Parliament decide whether the law needs to be reformed. So I found those arguments a little bit disingenuous. Nonetheless, Lord Neuberger and Lady Hale suggested alternative legal frameworks, which I think were both flawed. So all in all, not a stellar decision from the Supreme Court there.
I think it's also interesting, that they didn't give as much guidance on the fact that a blanket ban may not be adequately striking the correct balance. I feel like, a declaration of incompatibility would have been the right move.
Yeah, I agree. I think Lord Neuberger came out and criticized the current law. He said that having a lawyer from the DPP office investigate after a suicide whether the wishes of the patient were truly voluntary, etc., is not a satisfactory legal solution, and then went on to propose an alternative. Lady Hale said that the current law, and Lord Kerr said it's unlawful in accordance with their human rights. So it really was the very first judicial pronouncement we've had on the issue where they've gone that far and said that much. The previous case in Pretty, they said the current law is fine. It strikes the right balance. But we see that the majority of judges in this case thought the law was dubious, but only 2 of that majority were willing to actually declare it incompatible. The rest were concerned about the politics, which is like the first question you asked about the role politics plays. They were concerned about constitutional limitations and so on. And I think unduly so, because we have a very robust human rights framework which mandates parliamentary sovereignty, that famous Brexit word. But it's true, you can't, a court, unlike in the Netherlands or unlike, let's say, in France, they can't strike down a law and make it void that day. All they can do is say to Parliament, this doesn't appear to be human rights compatible. Debate it and make an issue on that, make a decision on that. And I'm surprised they didn't take that chance to do so. I think it's possible in a few years' time, a decision may arise where the court do make a declaration of incompatibility.
So just considering so we've already said that the UK has a blanket, does not allow assisted dying. However, we've already discussed the idea that the DPP don't prosecute people that assist, but you've also got the idea of the doctrine of double effect. So the idea that if a doctor administers a drug just in the basic medical procedure that they know will have an impact on their life and almost 100% likely will shorten it, that's not held to be euthanasia. And I just don't I don't see where that line is. I understand there's reasons for it, but it does seem to be almost, I think we've kind of talked about the differences between that and the Woolen intent in criminal law. It doesn't seem to be that different. So I was just wondering if there's any way to reconcile those.
No, not really. No, there isn't. So the Woolen, I presume this podcast has been listened to by law students. So I hope most people have read or heard of the Woolen definition of intent, which is that we can infer you intended an outcome if that outcome is a virtual certain consequence of your actions. We almost suspend that definition when it comes to doctors who inject a high dosage of painkillers, knowing, let's say, certainly, or even with reasonable foresight, but let's say it's virtually certain that that quantity of morphine will kill the patient. If the doctor can show that that quantity of morphine also had a therapeutic effect, they're not liable. And that's seen as a very important principle in palliative care and the provision of palliative care medicine. And I'm not criticizing that. Of course, I think doctors need to have legal certainty when managing severe, unbearable pain in a palliative care setting. The problem is when we draw a line and we say that principle is only justifying indirect euthanasia and not active euthanasia. And the reason for that is it's a Judeo-Christian concept whereby death can never be seen as a means to an end. You can never use a human being's life to achieve an outcome. But if death is a side effect from trying to, let's say, ease somebody's pain, that's permissible. So that's the idea. Well, they seem to think then that if you instantly inject a patient with, let's say, a lethal barbiturate, something which has no therapeutic effect, you must be using that person's death as a means to achieve an end, pain management. But I think that what we're dealing with there is just semantics. Well, the permissibility of helping someone to die should not depend on whether you label death as a side effect of pain management or as a means to manage pain. What matters is whether the patient is suffering unbearably and simply whether it's right or wrong to end that person's life. I find the doctrine of double effect to be largely a debate about semantics and not a very principled one. If you're interested in this and you want to find, maybe look into whether there's a questionable line between active euthanasia and current medical behavior, check out terminal sedation. So terminal sedation is another end-of-life practice, which we didn't really cover in this term because there would be so much to cover in medical ethics. But terminal sedation is when a doctor induces a patient into a coma, into a deep sleep using a sedative, and then removes artificial nutrition and hydration, and the patient dies that way. So it's a combination of indirect and passive euthanasia all at once. And really the line between terminal sedation and active euthanasia is very, very fine. In fact, I don't think there's a moral difference between the two whatsoever.
That's so interesting as well. So it is exactly like you say, that in practice, we have one of the most liberal versions of assisted dying in Europe, really, if we're allowing stuff like terminal sedation.
Well, that's a good point. I mean, so we have a liberal law on assisted suicide in that we allow people to travel to Switzerland with a loved one, help them commit suicide, return home, and the investigation process is all ex post the incident. There's no requirement that the loved one had an illness, etc. So that, in that sense, is more liberal than Swiss and Dutch law. But also in the case of indirect euthanasia and what's happening in palliative care units, there's very little regulatory oversight, for better or for worse. I mean, doctors don't like lawyers, probably for good reason. So they wouldn't like to see us coming into the palliative care units, double checking every administration of morphine. But the reality is we don't know what's happening to a great degree. We rely on the doctor's report to see if the quantity of drugs was indeed therapeutic and justifiable or not. But we accept that there's a certain behind the scenes practice going on with that type of end-of-life behavior. So, and I do think we could do more. We could at least require hospital and palliative care units to publish their guidelines and policies and have mandatory reviews about the essentially how they perform indirect euthanasia, and to make that more public and more transparent. But people aren't so concerned about that. That's not you never hear many opponents of active euthanasia voice their concern about the lack of regulation for indirect euthanasia or passive euthanasia. They seem to think that that's just a necessary part and parcel of end-of-life care, and there's something so so abhorrent and risky about active euthanasia that isn't present in the other case. And I think that's probably not looking at the whole picture, to be honest.
And I think it's quite interesting that you said about how a lot of the end-of-life decisions in a medical context are influenced by Judeo-Christian values. And especially in the UK, where we're now a majority atheist country, I find it quite interesting that a lot of medical law, because even if you look at abortion and stuff like that, is guided by religious principles.
Yeah, it is. And I mean, I say that, but I'm not saying that doctors in palliative care units are being driven by theological arguments or religious beliefs. But the principle is the doctrine double effect. Yes, definitely has that origins, but that's part and parcel of the history, theological arguments or religious beliefs. But the principle is the doctrine double effect. Yes, definitely has that origins, but that's part and parcel of the history of the state, and most Western European democracies are shaped to a large degree by Judeo-Christian theology, whether it's unassisted dying. Look at embryo research. I mean, they really ran into a wall because of the difficulties there, trying to deal with 21st century technological advancements and very historical theological beliefs. It's no easy task. But I'm not saying we should throw out Judeo-Christian concepts either. I think that's an important point. I do think they have a value. There is something about primacy of the individual, etc., which is fundamentally important. But whether we should accept them wholesale or we should look at them with a bit more nuance, I think it's up for debate.
Considering this issue in the present context, how do you think COVID-19 has and will continue to have impacted assisted suicide in Switzerland?
Well, that's interesting. In Switzerland, the Swiss government are granting special exemptions on a case-by-case basis to those who are traveling to Dignitas, so that they don't have to self-isolate for 10 days on arrival. So if you can show you're going directly to a hotel and directly to the Dignitas clinic, and then, or possibly, if it depends on where the suicide will take place, but if it's only in those two locations, you're permitted to enter the country and you don't have to self-isolate, etc. So other than that, I'm not sure what impact it will have from a Swiss perspective. But I think from a British perspective, COVID-19 has highlighted the inconsistency again in the current law, because last month the health secretary, Matt Hancock, did anyone see Matt Hancock pretending to cry on television last week? No, if you didn't check it, it's painful. But he came out last month and he stated that people traveling abroad for the purpose of assisted dying will not be breaking coronavirus travel rules. So traveling abroad for the purpose of assisted dying is deemed a reasonable excuse. And so anyone doing so would not be breaking the law. And again, I think that highlights just the inconsistency. Either you have a criminal ban with extraterritorial effect, or you don't. And I think this kind of middle ground, this compromise they're trying to achieve, is not in the interests of patients and people who suffer. Also, there's been reports of people who committed suicide earlier than they would have wanted because they feared they couldn't travel to Dignitas because of the lockdown rules. So I think although the health secretary has clarified this last month, it was 4 or 5 months too late. They should have been clarified in March or April, not in November, to say that it's okay for you to go ahead to Switzerland. I think that should have been addressed a lot earlier. And also that's a discredit to not just the government, but also the opposition for not raising that and calling them out on that and making a statement necessary. So it's a failing across the board by our politicians there.
I suppose that also raises the question of if people can and are permitted to go and access assisted suicide abroad, then the UK should potentially reconsider their law and kind of implement some more safeguards as well so that people can access it more safely.
Yeah, or start criminalizing those who return home. Again, I think the current turning a blind eye to what's happening in Switzerland, it's not a satisfactory approach for either camp, those in favor of a change or those who believe in the formal ban. Because if you believe in the formal ban, you believe it's necessary to protect vulnerable people and make no exceptions. Letting people travel back and undergo a minor investigation only to be told prosecution is not in the public interest isn't sending out the message you believe is necessary for a formal ban. And of course, those who believe in reform think it's completely unsatisfactory because we're just outsourcing the problem to another jurisdiction. Yeah.
So as kind of like evidenced in this entire discussion, this is obviously a very pertinent topic where we now kind of have representation in media, which of course has a knock-on effect in public opinion and interest. I mean, an example which of course has kind of really struck out to me is the story of Ayakito. I don't know if y'all have heard of her story, but she was diagnosed with spinocerebellar degeneration when she was around like 15, and her diary was published shortly after her death. And I think if I remember correctly in one of the chapters, she was like writing along the lines of, I write because writing is evidence that I'm still alive. And it's kind of stories like these kind of make this kind of, as a sector of law, a very gray area. So just to kind of finish off, like, would you say that we should just kind of live in the gray and have the law reflect that? Or would you recommend a more objective legal approach, as you said, with like all the safeguards and all the like?
Yeah, no, I'd go for the latter. I'd rather this is regulated instead of having a covert practice underground. And then the question is, what limitations do we put in place? And of course, you can limit it to those with physical illness, limit it to those over 18, limit it to a contemporaneous decision, not an advance directive. But I do think the current policy of just pretending it's not happening, and then when it does appear, not prosecuting, is not in anyone's interest. And then even in the cases which are prosecuted, you'll find that the juries are very reluctant to convict a loved one who's acted out of compassion and mercy and is now facing a charge of murder. And it's quite often the prosecution service will recommend a partial defense of diminished responsibility when somebody's charged with a mercy killing. So I'm not a fan of all these tricks and tactics which we're using to stop the formal law from being fully applied. All of that suggests to me the formal law is not adequate. And even if it requires a complicated, nuanced adjustment, we're capable of that. You know, we can look at other jurisdictions, we can look at their evidence, and we've a, if you like, a menu of options from the Canadian approach to the US Oregon model, to the Swiss one, to the Dutch one. And you can see what works best and what doesn't work best. Rather than the current ban, I just, again, I think we're failing those who are suffering unbearably and truly want to wish to die, but we're also failing those who may be vulnerably pushed and pressurized into committing suicide. We're not protecting them sufficiently either, which is an obligation the state have under the Human Rights Act, under Article 2. So Article 8 is the right to privacy, and you have the right to decide the manner and time of your death. But Article 2 places a positive obligation on the state to protect the lives of their citizens. And I think the law on assisted suicide is failing to sufficiently protect the lives of vulnerable people in this jurisdiction. What a grim note to end on. But it is a grim topic.
Mm-hmm. Oh, okay.
We're thanking you again.
Yeah.
Well, you're very welcome, and it's a great initiative. So well done on the podcast. So I'll be listening keenly to the rest of them.
Oh, thank you. So speaking of listening keenly, this podcast is actually on Podbean as well as on YouTube if you prefer to watch your podcasts. We also have an essay competition running, which is about the will of the people, that's in collaboration with UELS. So have a nice little entry, have a nice little think, and maybe have a nice essay writing experience this Christmas time. And then we are still accepting shorter publications for the blog, so that's on exeterlaw.org. So please get in contact with exeterlawreview@gmail.com, right? Fab. If you're interested in having your articles published. Yeah. We good?
Well, thank you very much.
Thanks for listening.